Добрый день.
Good afternoon, dear colleagues, dear friends. We are starting the session number 4 of our conference. All colleagues are gathering here in the main hall. And as you can see in our agenda, our session will be about new approaches in the professional training of judges, and we will discuss achievements, including many other things, in our Council of Europe program called HELP. This is about a legal training program for the representatives of different legal professionals, legal councils. This program is active in 47 member countries, but also not only in the member countries of the Council of Europe. We have good collaboration with the legal community of the Republic of Kazakhstan and of other countries of Central Asia. Therefore, we are really glad that at the end of our very productive conference, which was launched yesterday, we can discuss new approaches of training and professional upscaling of judges. As a moderator of today's session, I have a very simple task, I believe, because the participants of this session are very active actors of our program, and I cannot even imagine a better list of speakers to discuss HELP program. In this hall we have about 30 people, and it is also for those who are connected online, and we have a lot of participants connected online to our session via online platform. Please don't hesitate to ask questions. Take active part in the discussion, because the HELP is a driving force, mostly supported by the national systems, and mostly people engaged in professional training of judges in different countries, and that's what actually explains success of the program, why it is so highly demanded, because it is based on requests and inquiries from different national systems, and requests are even more broader than the training courses, even though we are trying to cover everything possible. The HELP program became even more demanded in pandemic, when the world shifted towards the distance communications, and in the last year and a half this program expanded and widened quite drastically. It is my pleasure to provide the floor for the introductory speech to my great colleague Eva Pasterna, head of the Department of Training on issues about judicial systems and human rights. Unfortunately, she wasn't able to join us offline here in Nur-Sultan, but she is here. She's connected from Strasbourg.
To us, and it's a great pleasure to give you the floor.
Thank you very much. Can you hear me well?
We hear you very well, and we see you very well too.
Okay, so thank you very much, Mikhail. Thank you for moderating this session, and I understand that me, as the first panelist of the judicial training, have the responsibility of showing participants the basics of the HELP program. But I am also going to tailor it to what has already been achieved in Central Asia. I'm very sorry that I cannot be with you presentially in Nur-Sultan, I would have loved to do it, but next time I promise I can go. I can be with you there. I'm Spanish, first of all, and I have the privilege of working with great colleagues like Mikhail, who is my boss, Cristina, Tigran. You can meet them there. And actually, a key person for you is Cristina, as she's the project officer who is in charge of Central Asia. I'm going to try to share my presentation now. And if there are some technicalities, Christina at the technical team in Nur Sultan can do it. Let's see if I can do it. I will. Can you see it?
I think it is being uploaded. Now we can see it. Yes, very good.
Okay, excellent. So what I wanted to do is just going beyond the classical presentation of HELP and really tailor it to what you can use of HELP. So HELP is first of all is the Council of Europe program on for human rights education for legal professionals, and it is a strong component of the rule of law program founded by the European Union and implemented by the Council of Europe in Central Asia. The main goal of this key and landmark program of the Council of Europe is to support legal professionals in the application of European human rights standards in your daily work. And we do it mainly by training. We develop courses that can be taken online, but with a very flexible methodology that can be adjusted, tailor-made to each region or country needs. So when we mean European human rights standards, of course, we basically refer to the European Convention on Human Rights, to the European Social Charter, but also to many other Council of Europe conventions. There are more than 220 conventions, out of whom 2/3 are open to third countries, like Kazakhstan, for instance. And then most of our courses, at least those developed since 2015, also include relevant provisions of EU law that can be also useful for the region, for Central Asia, in case you have partnerships or you are negotiating kind of trade agreements with the European Union. It's very important for you to understand that when we talk about legal professionals, we think of judges, prosecutors, and lawyers primarily. But more and more, because of the multidisciplinarity of the world we are living in, we can also add, or we can also reach other justice professionals, senior court staff, or prison and probation staff, even notaries, so, and sometimes even other professions. Let's think of a course on bioethics, for instance. It is good also for health professions, or freedom of expression. It's good also for journalists as well as justice professionals. And then, while we develop our courses, thinking always on practitioners, on working professionals, on current professionals, we have realized that our courses are very much in demand from universities, especially law faculties, and especially for the last years of the degree, or PhD students, master degree students. So think that this can also benefit the students. Actually, when HELP was created more than 15 years ago, the idea was to cover judges, then gradually prosecutors and lawyers, and also university students. We're still anyhow focusing on legal professionals. And I want to let you know that HELP was created 15 years ago when the Strasbourg court that you may have been discussing these two days was about to collapse because of the overwhelming coming of cases. And at that point, it was decided to, first of all, reform the court, make it more efficient, more agile, and um, at the same time to create the HELP program so that it would allow to national justice professionals apply the European human rights cases and have less cases reaching the Strasbourg court. So you, as the Supreme Court also is organizing this conference, you're very much interested on your national judges applying the human rights standards. In the end, they're universal, the international human rights standards, so that you will have less cases reaching you. The main three components are the network, the online courses and the platform, and the methodology. So here you have a picture of 2 years ago when we met presentially. It is becoming a tradition that the president of the European Court of Human Rights joins this annual conference where we met the representatives of the judicial schools and bar associations of the 47 member states of the Council of Europe, to which we are also pleased to add year by year new members, even beyond the Council of Europe member states. So this is the case for Central Asia from Kazakhstan. This year we met in July and we have some representatives from Central Asia. We also have, beyond the Council of Europe member states, Morocco and Tunisia, who sent also representatives to our annual conference. The second component is the online courses, is the platform. This is a picture of the online platform, which is free, which is open to anybody who has an account, and it's very easy to open an account. It takes 2 minutes, and will allow you to access all the HELP courses, including the national versions or translations of the courses into, we have a lot of courses, more and more, into Russian, and gradually we will be having some courses translated into your languages. The methodology, I wanted to take a very simple approach, as for many of you it may be the first time you're hearing how we work. It's a bit more complex inside, but to make it clear, first of all, we developed this HELP model course. We do it in English. We do it with the best experts we can find in the Council of Europe and at European level. We'll have an example later. Here is a screen of a very interesting course we developed on human rights in sports. Then we need to develop the national version. And here you see the same course. The replica is an identical replica of the course that has been translated into Russian. But the thing is that to make a real national version, we do not only need to translate it into Russian, we need to also add complementary information regarding mainly 3 elements. The national law, in that case would be the Russian law, the national case law, so the national jurisprudence, the Russian jurisprudence that is relevant to the topic, and the practice and the context. Even within such a large country as Russia, we may have different practices depending on the regions. So this is not the work of HELP. This is not the work of the Council of Europe alone. This is the work already of the national partner, of the national institution that covers this national tutor, and that makes sure that the national tutor mm, adds the relevant information, and it's crucial. Why? Because later, once this course is launched and implemented at national level, is, let's say, piloted, and here you see that usually we organize one presential session of a course launch to be followed by tutoring online and online learning individual by these judges, prosecutors, and lawyers who are very busy, but who may find time, who may find 2 to 3 hours every week or every 2 weeks to go and continue their learning tutored by a national tutor. In your region should be from Kazakhstan, from Uzbekistan, from Tajikistan, from Kyrgyzstan. So you can see that the same course that we develop in English has to be translated into the national language, or a language which is understood by the region where it is launched. But then later, it has to be complemented by this national law. May not be the same, even, let's say, we translate one course into French. It will never be the same, the national adaptation of France or in Belgium. The translation will be the same, will be in French, but each country has its own language. Same when we go beyond the Council of Europe in South Mediterranean. We may use the translation into Arabic for a number of countries, but each country in the South Mediterranean region has its own features, its own laws, its own case law, its own practice. Then at the end of this launch, usually presential launch, now because of COVID, what we had to do is replace these presential launches by virtual launches, but then we continued the tutoring online. The participants can obtain a certificate, and this certificate can be a joint certificate issued by the Council of Europe and the national institution. So the Justice Academy in Kazakhstan or in Uzbekistan or Kyrgyzstan, the responsible institution in your country. Here you have a visual representation of some of the 38 online courses, help courses that exist. I wanted to highlight the basic courses. In the words of our Secretary General, the bestseller is Introduction to the European Convention on Human Rights and the European Court of Human Rights. It takes really 5-6 hours of online learning, and you can get the essence, the core of the convention, the court, and the execution of judgments. We develop it with colleagues from all these entities, bodies, and the court. Then we have topics that I know interest Central Asia, trafficking in human beings, with the new module that we added on for the purpose of labor exploitation, data protection, privacy rights, discrimination, asylum, child-friendly justice, business and human rights, bioethics, sports. Here, to make my presentation shorter, I just listed the courses, and I highlighted in green some that, based on the training needs assessment that has been done for Central Asia, you have expressed your interest. Apart from some that I mentioned, there's also pre-trial investigation in the light of the European Convention. Ethics for judges, prosecutors, and lawyers, I will present it in a minute. Procedural safeguards in criminal proceedings and victims' rights, and violence against women and domestic violence. The course on violence against women and domestic violence, I need to say that it has been one of the most demanded, including during the pandemic. So are they useful? Are they interesting? The courses, do they work? Seems so. Seems so, because you can see here the data and how the use of help courses have been exponentially growing, but especially we had a peak when the COVID hit the world. So in 2020, we grew a lot, and we continue. Currently, we are over 92,000. These are data. This is a picture we take always of the number of users in June when we organize this annual conference, where I hope to see many of you next year in Strasbourg. And you can see here the number of users from the European Union, from the Western Balkans and Turkey, from Russia, from Eastern Partnership countries, and South Mediterranean. Since we have started later to be operational in Central Asia, we do not yet have the figures of other regions. But thanks to this rule of law program, we're starting. We would like to cover the 5 countries: Kazakhstan, Kyrgyzstan, Tajikistan, Turkmenistan, and Uzbekistan. Of course, within the region, it's normal, it's natural. We will always have pioneers. We will always have frontliners and countries that can develop to another rhythms. So we may have, so far, it is the case, we have more users from Kazakhstan than from other countries. What did we do? First of all, to fulfill this important mission of national tutors that are the stars later when they develop the national versions of the courses. We had to train people. So we ask for candidates. These candidates are also appointed by the national training institutions or by the national courts. And then we organized in April 2021, so a few months ago, a training for 37 legal professionals from the region, from Kazakhstan, Kyrgyzstan, Tajikistan, Turkmenistan, and Uzbekistan. Not all passed, because we organize this training and then they need to be certified. So far, we have 25 certified tutors out of these 37 original ones that started, which is normal because it's not that it's not that difficult. It's sometimes a question of time. And once they are certified, they can get also this possibility. They get a certificate, but they get also the possibility of becoming national tutors. In the case of Central Asia, we have started with translating the course on rights of persons with disabilities to Uzbek. And we will launch it in December for judges in cooperation with the OSCE in Uzbekistan. We intensified our work as we could gradually travel. And then we had the participation in the annual in-serving MIGIMO training in Moscow of a good delegation from Central Asia, so that you can see that gradually we are reaching more and more people. And now I would like to go quite quickly, but I would like to present the help course on ethics for judges, prosecutors, and lawyers. This is a course that we have developed with our colleagues from the Secretariat of the Venice Commission that are present today in the conference, the European Commission for the Efficiency of Justice, otherwise known as CEPEJ, the Consultative Councils of European Judges and Prosecutors, and the European Court of Human Rights. And what we would like to achieve by the end of the course is that justice professionals, judges, prosecutors, lawyers, understand the purpose and importance of ethics in the administration of justice, learn the international and European instruments, and then identify the key concepts and the differences also between values, ethical principles, disciplinary measures, ethical behavior. This is a very, very interesting course that we have launched so far in EU countries at European level, and then nationally we're launching it in Lithuania, in Spain, in Italy, and progressively in other countries. These are the key people that authored this course. The closest to your region would be the Deputy General Prosecutor of Armenia, so to say, but you can see that there is a variety of cultural, different legal systems, different parts of Europe, north, south, east, west, and this makes the course very, very rich. There's an introduction about why these professional ethics matter. As I said, values, principles, the concepts, and the difference between ethical principles and disciplinary rules. Here are the sources on ethical conduct, the treaty norms, United Nations, where the Central Asian countries also belong to, Council of Europe, European Union, and then it's very interactive. These are just screenshots of the course that you can take. This is, since this conference is mainly for judges, this would be the content of the module specifically developed for judges. The main principles, qualities and virtues, some practical tools that you can use, some practical examples, and a quiz. So it's quite easy to do it. For prosecutors, there's an important chapter about relation with the media. And then this is in my presentation that can be later shared by my colleagues. You can click here, access this course. You do it by yourself, the English version that is available now, and you could even get a statement of accomplishment. It would take like a 9 hour to do it entirely, but our idea would be to translate it into Uzbek, into Kyrgyz, into Kazakh, so that you can take it later into your national language, and that it is complemented with this additional information that the national tutors have. Let me finish this presentation just with a list of people, the core team of help. For you, the most important person would be Kristina Korlova, that you can access and you can tell. And thank you very much for your attention. Spasiba.
Спасибо.
Thank you very much, Eva.
And I would like to thank you especially for making the HELP program so dynamic. Of course, I intervene in different HELP events on a monthly basis, sometimes even more frequently. Last week we spoke to our EU partners, our HELP focal points in the European Union. But every time I see your presentation, I notice something new, so novelties. So the HELP is perhaps the most dynamic program in the Council of Europe, and HELP is very reactive, as I mentioned at the beginning, to any request we receive from the national level. And this is how we think the genuine interaction between Strasbourg and our national partners should work. And what you mentioned about HELP certificates, I would like to also to say that it is becoming a brand, so it is more than a formality. So I know the HELP certificates are considered increasingly within our member states as an evidence of achievement in professional training. And of course, we here again, we are at the disposal of our national partners to ensure that HELP is included in the process of national professional training and acknowledged as such through HELP certificates. Now, я перейду на русский.
Okay, I will switch to Russian language as we are getting back to Nur-Sultan. And according to our agenda, we have several reports of our great partners from different countries of the Council of Europe. From Kazakhstan, the first such report will be the presentation of our great colleague, Diana Skobiala, Director of the National Justice Institute of Moldova. who is the coordinator of the HELP program in Moldova. The report will be called Integrating Online Training Tools in Professional Training of Judges, Experience of Moldova. And I can't help myself of not congratulating Diana on selection of her judge as the human rights judge. You are now in the capacity of the director of the National Institute, but you have a bright future ahead of you and serious practice within the frames of the European Human Rights Court. And thank you very much for joining our today's conference. We will be very much interested to learn about your experience on working on the HELP program. The floor is yours. Thank you very much, Mikhail. I also would like to congratulate you with the same appointment, with a great position that is waiting for us. Distinguished colleagues, good afternoon. I would like to welcome you on behalf of the National Institute of Justice of Moldova Republic and demonstrate a productive outcomes of cooperation between our institute and HELP program. Today, I'm going to introduce to your attention the report of my latest report in the capacity of the director and the national coordinator of the HELP program, which actually is a little bit sad for me. However, we are very happy to have this cooperation and to have this unique experience. And I hope that my forwarders, those who are coming to replace me, will facilitate introduction of the HELP course in the mandatory training program. What is HELP program? Eva already explained to you very well. And this national focal point every time when the HELP course is being launched is explaining to the participants what the program is about, because there could be different background of the audience with absolutely different kind of programs. By listening to Eva, I recalled my first experience on launching. It was in 2013. I was just appointed as a national focal point. I was not a director because I became the director a bit later in 2015. And wanted to point out that it's important for the national focal point to have very close connections with the national institution responsible for this training, professional training, because official launch of the program happened only in 2015, when I became actually the director of this institute. At that time, the first course that was launched by us was Introduction to European Convention on Human Rights and the European Court on Human Rights. So this is a fundamental course that every country and every institution shall start with in order to commission the HELP program in any country. I don't know, maybe in Kazakhstan there would be another experience. It depends on the needs of your beneficiaries. Prior to this year, we have launched 13 courses. It was a long way. We have developed our own methodology. Eva presented to you 4 stages, and based on those 4 stages, we have developed 10 stages, 10 fundamental steps from the decision on launching the program up to the moment to introducing this course into the program. So each course shall pass these 10 steps. If you notice, at the very beginning, each year was unique. In terms of launching one course, in 2015 we have launched the first course, Introduction to the European Convention on Human Rights, but in 2021 we have introduced 3 new courses. Yesterday we launched the last one, which are the statements based on hatredness. I was supposed to participate at this launch because I'm still the national focal point. And another course will be launched in November, but I will tell you a bit more later. How the decisions are being made about introduction or commissioning any course. This decision is to be made, of course, by the National Justice Institute, and everything depends on the priority on professional training for this year. We are trying to plan in advance 1 year ahead. And because we are responsible for the basic training and lifelong learning of the prosecutors and other players in the justice process, and distance learning program as well, and TOT. So within the frames of 4 different programs, we are planning different courses. However, within the frames of these online courses, we integrate those online courses into programs on this initial training and second lifelong learning program, which is an optional, because every judge or the prosecutor has an option to select its focus or what kind of courses are needed to be passed this year. So this is an optional protocol for us. You've been introduced these 10 stages. The first stage is about translating the course. Any help course that is planned to be launched in Moldova should be translated into Romanian language, which is the national language of our state. And this is organized by our partners in Strasbourg. Help program itself deals with that. We are only dealing with verifying the translation, but National Tutor is doing that, except for some new courses that we have already launched or planning to launch, where we still do not have a translation. Then, in cooperation with Help program, we are dealing ourselves with the translation. We do have experience on bioethics that we commissioned. This course was introduced in 2019, actually. This is a unique course, very dynamic. And it's made of several modules. Hourly modules, we have different methodology applied here, and also breakdown by beneficiaries. We have enlarged the scope of beneficiaries. And the new course that we are planning to launch in November, this is Environment and European Convention. In this case, we are dealing with the translation and then verifying the translation. This is what Eva mentioned about verifying translation and adaptation of courses. So these are 2 different stages, actually. Since the moment that we decided to launch the course, we have received the translation. We need to assign a tutor. What this selection is about, of course, we are focusing on the certified tutors by Help program. It could be quite different at the initial stage. And for that, we have organized a little bit later in the trainer on certification. Currently, we have 18 certified tutors, so we have quite a variety to select from. Initially, there were 2 tutors selected. One tutor was a certified Help tutor, and the second trainer or tutor was an expert practitioner in this area. And this symbiosis worked perfectly for this course, on each of the courses, actually. But at this particular moment, I would like to mention that all of our tutors are certified by HELP program. So these certified tutors are verifying the translation, and if there is a need, introduce adjustments, edit, and modify the content according to the right terminology. But from our point of view, from the point of view of legislation of Moldova, you are able to see a bit of a backstage, how the translation happens, how translation verification, proofreading happens. So the first column is not about us. The second column is about English version. And the third column in this table, this is where we are working with. The red one, there could be some edits. And we have received this translation from our colleagues from Strasbourg. So the red kind of crossed items, you can see this adaptation of this translation to the national legislation, which is also very important because it eases training process for our participants.
And after that, after receiving translation, tutors adjust and tailor these translations to the local legislation and local context. What this adjustment is about and tailoring is about. There are specific examples from EU, from precedents, from national legislation, from local courts, by scientific research. It can be PowerPoint presentation information from different information lists or from different articles, additional links to websites. It also can be different videos we are uploading. And sometimes we have specific tasks set for our and assignments for our participants. It can be essay or can be questions. It is important for certification or at the final evaluation of knowledge at the end of every course. After tailoring and adjustment, we move to the application stage when we enroll participants. And if it's about our institute, on our website, we publish announcement that we are planning to launch a course, and our participants, they enroll themselves. So actually they submit applications. We enroll up to 30 participants. Our latest experience showed even up to 40, 50 participants. Why am I saying? Because not every applicant will go till the end, till certification. Not because they will actually underwent all these assignments, but it's very difficult to focus and actually to keep participants focused, because those are very busy people. We are speaking about judges and prosecutors in majority of cases. Here I would like to show you who are our participants and audience in general. Sometimes they are quite unusual. This is our unique experience with students of Moldavian State University. Our main participants are prosecutors and judges. This is the two last columns, and our assistants, our legal beneficiaries, and others, for example, civil servants or students. That's up to this is at our discretion, or we can expand that for all the lawyers, because following the law, only the lawyers and attorneys who are providing legal assistance and counseling on a obligatory basis are considered to be our target audience. Also, employees of the courts, consultants to the prosecutors, judges, and our audience. We call them students of the national university. They are not actually students. They are our attendees who are enrolled every year. In September, we have new enrollment. This is unique experience. In 2019, we had this experience with the students of Moldova State University. This was my personal experience because I am also a professor at the university, and I decided to have such experiments with master students, and we liked it very much, with the basic course on human rights and European Convention, and for the justice, children-friendly justice. We also had access of women to justice, and that was one of our priorities. Therefore, we also enrolled students and opened the course for them. Going back to our stages, next stage is official launch of the course. By the way, enrollment of the students, that's a tutor, and tutors take care of that, handles the whole procedure. After tutors are assigned, they are made responsible for all the stages in close cooperation with our university, with our institute. Basically, our trainers, they are our tutors, certified tutors. Official launch of the course. At the initiation meeting, at the kickoff meeting, we launch this course. We have speeches from coordinator or from our top management. At the moment being, that's the same person, tutors, mentors, and a representative of the help secretariat. With great pleasure, we always attend to the presentation of Eva or Anna, and of the local Council of Europe office in Chisinau. What about the course? This is stage 7. The training itself, it can last, depending on the course, depending on how comprehensive and dynamic the course is, it can last from 6 to 8 weeks, so the average duration. And during this period of time, students should actually submit all the assignments, look at the additional resources, undergo the course, look at the cases. As there are also discussions on the forum, it is very important because tutors, they make attendees more interested through the discussions. And through this platform, it is a constant collaboration and communication with tutors and attendees. The final evaluation of knowledge, that's up to the tutor, because if you can actually notice that there are specific tests for every course, but they are elective. They are only for participants. And for final certification, tutor develops tests, and we upload that on the platform. And basically, we are working on a help platform. It's Moodle, and following Moodle methodology when we launch the course. But when it is integrated, it's step 10. We transfer it to our platform, Ilias, and it's not very complicated process. Certification also happens officially, and don't get upset if not all your participants came through till the certification. During the first course, for example, we had 25 people enrolled and only 8 people are certified. But for the first course, it was fine. But at the last course, I was really surprised in terms of the access for women to justice. Almost every participant was certified. Probably it was due to pandemic. People got more time. I would like to share some figures for 2021. This is a big achievement, big result. We can see them better here on this slide. This is result of 2021 participants who were enrolled, 384 people. And for the certified, only 43 were certified. That's without the final course. We haven't updated our database yet with the inclusion of the final course, but the initial training, it's really good. 140 people were certified, and that's the difference, that for a continuous training, it will be an elective tool, but for the initial training, our attendees, they do not have a choice. It is part of the mandatory program. If they are not certified, then they will have serious consequences with graduation. And for the moment being, as I mentioned earlier, we have 13 courses launched. 18 tutors were certified. Regarding our projects, this is an input for initial training. We've implemented 4 courses and made them mandatory disciplines. This is an introduction to European Convention, introduction to Article 5, third article, and also access of women to justice. Why we decided to implement these 4 courses? And the first course was implemented this year and became part of our mandatory program, because not all universities in our country have the course on convention, and somehow to adapt all our attendees to the human rights following European Convention, we decided to include the 3 courses to our first semester. And only after that we have simulation on European Convention, when we have understanding that they have basic understanding and knowledge on European Convention on human rights. And but in the continuous education, we basically have all the other courses. All the 13 courses are part of the mandatory program, but prosecutors and judges, they have a choice every year. And when we have certification, we decide on number of hours mandatory for them. What is the requirement is it varies from course to course, but as a minimum it is 8 hours maximum. On bioethics, for example, it was 40 hours. What is a general requirement for 1 year per 1 prosecutor or 1 judge? In the pandemic, it was very important and required resource. We are planning in the future, we are planning to launch 3 courses. This is, as I mentioned earlier, environment and human rights, CPT standards of the Committee and on the ethics for judges, prosecutors, and lawyers. It is still a piloted test at the test phase, but we are planning to implement that next year. This is a short presentation of our experience. I hope I haven't spoken too much. Thank you very much for your attention, and if there are any questions, I will be glad to take them. Thank you very much, Diana. On the contrary, I believe it was a very clear methodological description, which is actually what we need, because as I think in Moldova, the use of the program is at the very high level. And very often even more advanced in other countries. Therefore, this methodology of course preparation you described in so many details will be quite interesting, including the translation stage, because translation, as you very rightly mentioned, has to be adjusted and tailored for the course to be within the legal context of internal legislation what's very difficult to be achieved only by linguistic translation. Therefore, it's not only about language translation, it's also about legal specifics to be part of the judicial system in the country. And you showed us how it is done in practice. Thank you very much for sharing your experience. How the use of the program is the right way to learn more about the EU laws and regulations, not only about convention, but also within the university degree trainings, since we are at the stage of developing university networks on Council of Europe regulations. This is a new project which is not launched yet, but I think it has a bright future ahead. Thank you very much. Now let's move to our next presentation. It will be about the experience of Greece, and it will be dedicated to the challenges and solutions of professional training for judges. Presentation will be shared by our outstanding partner, coordinator of the health program in Greece, and we can see Petros Alikakos already on our screen.
Great to see you on the screen. Greetings to Athens from Nur Sultan, and it is a great pleasure to give you the floor.
Thank you, Mikhail. Thank you. I would like to thank the organizers for having me in this great conference. Actually, I'm in Thessaloniki, and today is our national day here in Greece. We commemorate the beginning of the war against the powers of Axis, 1940, the Second World War. So here in Thessaloniki, you have this moment a big military parade in the presence of the President of the Greek Republic. My name is Petros Alikakos. I'm a judge. I'm the help focal point since 2013, and I am one of the main tutors for the e-learning courses of the help program here in Greece. I would like to begin my presentation with a little bit about the Greek School of Judiciary. I'm going to share my screen. As you can see, this is the building, the headquarters of the Greek School of the National Greek School of Judiciary. It is based in Thessaloniki, and it is founded in 1995. So it's we have 26 years experience in judicial training here in Greece. We believe as a school that the importance of judicial training is very high, not only as an initial training, but also as an ongoing training. I think that is a European acquis this time to say that judges and prosecutors should be trained before they appoint their appointment, and of course while along their career. My school has 4 directions. Actually, the board of directors comprising of the heads of the Supreme Court and some legal professors, law professors, and lawyers. It is the head of the school. The school is independent from the Ministry of Justice. And since we here in Greece, we don't have a high judicial council, but 2 councils, one for the civil criminal justice and one for the administrative justice. It is also independent from these councils too. We have a general director and one director of financial planning, and 3 directors, one for civil criminal justice, one for prosecutors, and one for the administrative judges. You can see even below the rest of the organization chart of the school. The main challenge when the school was founded was in what age should the participants should enter the school, and it is decided since 1995, and it is the same even now, that lawyers with the age of 28 could be eligible for the entry exams. The only way to pass in the school is the entry exams at the age of 28, and because we believe that a judge should have the experience of a lawyer, every participant in these exams should be a lawyer for at least 2 years before. The studies in the school is about a year, and after this year we have 6 months practice stage in the courts. When this practice is over, the students, the trainees, are appointed as judges and prosecutors, and they are appointed to the specific courts. During the time of pandemic, this time of crisis, we had to resolve the problem of the banning of face-to-face lectures, so we used the online sessions and webinars. Of course, since 2013, but mostly this year, 2021, we used a lot the help platform, and I will explain to you in a moment. Here you can see this data is from June 2021. My small country, Greece, is in the 7th place. Yes, as user in the help in different help programs. I can tell you this number 3,596 is for judges, prosecutors, and lawyers. Here in Greece, we are 5,000 judges and about 30,000 lawyers. So you can see that this is a great number, and here in Greece, we are exploiting in a good way the help program. Up to now, we have launched here in Greece several several courses. We began in 2013 with the alternative measures to detention, and then we had the course on labor rights, 2016. 3 times the introduction to ECHR and the European Court of Human Rights, and now for the first time we are having the course about ethics for judges and prosecutors. I want to tell you much about the national adaptation of the course. As Diana said thoroughly, and it is the same way here also in Greece, how we develop the course with the national tutor and the participants. And of course, Eva in the beginning explained to you the bigger image of health program, so I won't go much into that. But I would like to stress the importance of the courses. especially during the time of pandemics. This time, this month, October, we are having 3 courses that are being developed here in Greece. The one, as I said before, is about the ethics of judges and prosecutors. About 48 colleagues are participating. The second is the introduction to the European Convention of Human Rights. And there we have also 30 judges and prosecutors. And the third is the course on asylum and unescorted migrant children for administrative judges. Again, we have about 40 judges as participants. So I would like also to thank Eva and the Secretariat for this great collaboration with the Greek school. Coming back to the school, I would like to stress that the ongoing training is not mandatory for Greek judges, but with the exception of the major legal changes. For example, this summer we had passed a new law on family issues and divorce and the custody and the best interest of the child. So the school decided to train all the civil and criminal judges of the first instance, about 1,000 judges, and this was happened very successfully. I believe, and the school believes, that the major issue is to form the judge of the 21st century. And here in Greece, we believe that this could happen through training in ethics, in new technologies, and of course in human rights. We believe that the judge should be close to the society and its needs, and the judge should be informed about the economy and the climate change, along with international cooperation. And for this international cooperation, help plays a very important role. And again, we would like to thank as Greek School of Judiciary, the help for the collaboration so many years. Thank you very much, Mikhail, and I would like also to congratulate you for being the new judge on behalf of Russia in the European Court of Human Rights, and also to congratulate Diana with this opportunity. Thank you very much.
Thank you. Thank you very much, dear Petros, for your very kind words. And thank you very much also for your report and for being with us, all but online, on the Greek national holiday, which is celebrated today in Greece. Your PowerPoint presentation was very illustrative, and I hope that it will be available, and the same applies to Diana's presentation for our participants, because we are planning to make a summing up of this conference in writing, and of course we would readily append all presentations to the summing up, because I'm sure that there is a lot of interesting experience on how health courses are implemented in different legal systems, and the Greece is another bright example of this implementation. So thank you very much for your report. We will switch now to Armenian experience, and we have with us here in Nur Sultan Sergei Arakelian, the rector of Academy of Justice of Armenia. And Sergei's report will deal with the introduction of health courses in the system of compulsory training and education of judges, prosecutors, investigators, and lawyers. So it is a very interesting subject, and it is a great pleasure to give the floor to Sergey.
Thank you, Mikhail. Я благодарю за то, что...
I'm really grateful for giving me the floor. For me, it's a great honor to be here and to have an opportunity to introduce the Armenian experience in the area of educating judges, prosecutors, investigators, and other representatives of legal profession. First of all, I would like to congratulate our respectful colleagues on your selection as the judges to the European Court of Human Rights. We have a long-standing cooperation with you, and I would like to mention that cooperation with Ms. Scobiola is not only productive but pleasant. So I wish you all of the success, distinguished colleagues, and I'm sure that the practice of the European Court on Human Rights with your participation will only be gaining benefits. I would like to congratulate our Greek colleagues on the occasion of their national holiday and switch to my presentation. I will try to be brief in order not to take much of your time, and we'll try to fit the timing. I suggest to you the following structure of my presentation. First of all, I will briefly introduce to your attention the judicial system of Armenia, the main areas of activity for the Academy of Justice, and as previous colleagues quite in detail described the help courses, the specificity of the procedures starting from the official launch to the certification. I'm not going to talk about those aspects. However, I wanted to draw your attention on the main differences that are being applied by the Academy of Justice of Armenia. Okay, the general information about the judicial system, you can get that by studying articles of the Constitution of Armenian Republic. In this case, I would like to draw your attention to the circumstance that in the cases specified by the law in Armenia, some specialized courts can be established. Now, apart from the administrative court in Armenia, we have the bankruptcy courts. And now we in the process of reforming those courts, and in the nearest future we are planning to have anti-corruption court. So this is the overview of the judicial system in Armenia. Could you please have the attention on the last point, which is the Supreme Judicial Council, which is the supreme government body that guarantees the autonomy of courts and judges. We have, according to the judicial system, we have some statistics about well, by analyzing these statistics, we can have a total number of judges we have 240, and not counting for the 9 Supreme Court judges or Constitutional Court judges, they are only responsible for administration of constitutional justice. And coming back to the educational process and training being conducted by the Academy of Justice of Armenian Republic, our academy is independent, is not subordinate to any institution. It was established according to the specialized law on the Academy of Justice, and the management body and the board. The board is responsible for policy development and implementing main areas of activity of the academy. Academy functions as of January 1st, 2014. And on this picture, you can see the premises of our academy from the yard and outside. The main areas of the activity of the academy is training, which is initial training for the candidates, not only as judges and prosecutors, but investigators for the investigation committee of Armenia. This is the uniqueness. Secondly, we are responsible for retraining or professional development of the acting judges, prosecutors, investigators, not from the investigation committee, but from the specialized investigation service of Armenia. We're in the process of liquidating the specialized investigation service, and based on that, we are establishing anti-corruption committee, which will be responsible also for the pre-investigation on corruption cases, and they will also become the students of our academy. We are also conducting retraining or professional development of the civil servants of the Judicial Department, Prosecutor Office, and Investigating Committee, and bailiffs. We are also doing specialized trainings for the judges, prosecutors, investigators, and bailiffs. This specialized training is aimed at improving the skills and developing knowledge on specialized and armed forces use. As for the, for example, for the prosecutors, investigators, and bailiffs, this type of training is mandatory. Then for the judges, is a voluntary type of training. However, it demonstrates that many of our judges are willing to take this specialized course. In terms of the retraining is mandatory for all the above aforementioned professions. The judges are being retrained in a mandatory way every year, while prosecutors and investigators once a 2-year period. In the upper row, you can see the pictures of our training room for the court hearings. The second row is our hospitality complex, and the third one is our library. As for the training methods, according to the law on the Academy of Justice, it's envisaged that the training is provided in the face-to-face and distance learning forms. So in case of the initial training, which is the beginners training for the judges, prosecutors, and investigators, is done only in a form of face-to-face training. So here distance learning methods are not applied. In this regard, it should be mentioned that in average more than 400 judges, prosecutors, and investigators are participating in trainings in the form of distance learning courses. I would like to elaborate in this case the peculiarity of our educational system in order to demonstrate why we select only 400 people and not more, and why they are selected at all. According to the law, for annual retraining, there are 80 academic hours that are being prescribed. Out of them, 40 academic hours are being delivered for the general subjects and also the related topics. On psychology, for example, we do have subjects related to psychology, being in stress, foreign languages, corruption fight, the practice of the European Union on human rights. So this part makes up 40 academic hours, and the other 40 academic hours are on specialized, like on the pressing issues of the civil, criminal, or administrative law, as well as procedures. According to the law on the Academy of Justice, we are supposed to have that on the specialized subjects. They shall be taken in a face-to-face mode. But due but these general subjects, they do have choice, either face-to-face training or one of the distance learning courses. So we did develop our courses ourselves, but jointly with other international institutions, we have 8 distance learning courses. However, the key component of the distance learning courses is the educational platform of the Council of Europe, which is called HELP. The same procedure is applied to Armenia, but I would like to mention the same the last step, like in Moldova, which is integration into the mandatory educational program. We are not integrating HELP courses. We do give the choice, free choice to our students. However, we applied a certain measure, like by proposing our students to select one of these, but by selecting the distance learning course or HELP course, for example, after, well, having passed this course, they are acknowledged as if they have passed this first part of retraining process, and the experience shows that our students select platform HELP more and more. Here you have the main courses which are adopted in the educational process by the Academy. The procedure is absolutely the same, almost the same as was described. The number of participants, meaning the students, which is at the moment of launch, official launch, and similar, like in other cases, it's not necessarily that they all successfully complete the course and getting certified, and they are considered to be fully past the retraining course if they have been certified. For example, if they selected some HELP course, if they do not get a certificate, they are not considered to have passed the mandatory retraining course prescribed by the law.
Main courses, we adjusted 9 courses, not only in line with national legislation, but also to the justice system of Armenia. And particular interest was the course about violence and domestic violence against women. This course was organized 3 times in 2017, 2019, 18, and 2020. And it was such a successful experience of implementing this course that on the basis of that, our management council with this topic had some offline courses with some changes to meet offline requirements. It is part of our obligatory program, not only for the existing judges and prosecutors and lawyers, but also for candidates. Candidates, they don't have a possibility following our legislation to have online or distance learning courses, but as experience shows, here you see that representatives of other professions in different courses, including the HELP program, and within these other representatives, we have our candidates, and also we had students from Yerevan, and not only from Yerevan state, but other state universities of Armenia. They were enrolled into the course, and I think it is a positive experience. And let me provide general statistics, and with that I will probably be done. And for the overall number of participants, for 9 courses, 288 participants, and most of them most of the participants are judges and prosecutors. For lawyers, I would like to mention specifically that lawyers have a separately organized launches of the HELP course. Here we have numbers for the joint lounge, where we had also our lawyers present. And for representatives of other professions, we also had civil servants from different structures, healthcare workers, social workers, in particular for the course which was about combating violence and domestic violence against women. As for the dropouts, we have only 17.7% out of the total number. And that's what I wanted to present. We will be glad to share our experience. If you're interested, we will be glad to share our knowledge. Thank you very much, Sergey. Thank you for very good statistics, for very representative statistics you showed at the end of your presentation. I have a question regarding the last figure. 17% of dropouts are those judges, but I mean not only judges, prosecutors and lawyers possibly. And that's not an exclusion actually. It is a good indicator. Diana is hinting me now, because if such a level or share of dropouts, how can you comment on this figure? It's always room for growth, room for improvement, but how should we act? You know, like, I think it is due to the reason that it's not obligatory part of our training program. As I said, they have a choice. It is an elective course. We do not include help courses into our mandatory and required courses. But if they choose help course, they have to get certified in order to get specific mark in terms of retraining. And in this case, we have annual growth of interest, because it's also quality of the help courses, help of this, also quality of the certified tutors who work with our attendees, and mostly they successfully finish these courses. That's probably the key reasons I mentioned previously. Diana, would you like to add something? Yes, actually, very important thing is that how tutor provides supports and feedback to the participants, how active he or she is at the forum. They always use all the types of connections, email, phones, but it is beyond our control and power to influence time and schedule of prosecutors and judges. They are very busy. They have their own workload, but 100% certification, it's only for candidates, for judges and prosecutors. If they are our candidates, they will not be allowed to go to the next stage if they are not certified on obligatory courses, on the mandatory minimum requirement. Thank you very much, Sergey. Thank you, Diana. It was very important to clarify this moment, because statistics is important. However, and whatever we do, we still have to look at statistics and follow on the results of the program. I know that our secretariat follows on these figures quite closely. We will include your statistics into our data. Thank you very much for this very interesting presentation. Now we move to Russian Federation. Our next speaker, from as an expert in the area of the criminal procedure, and in a broader sense, a very well-known expert, Ms. Oksana Kachalova, head of the Scientific Direction of Research on the Problem of Criminal Proceedings, professor of the Department of Criminal Procedure Law of the Russian State Municipal University, and also under the Supreme Court of Russian Federation, a very long but justified title, because this university is partner of the health program from the very beginning of our existence, and now for the Russian Federation, health is very active there, and the presentation by Oksana will be dedicated to the health program as a tool of international integration. Good afternoon, dear colleagues. Thank you very much for giving me this opportunity to speak at this event. This is well organized, high level event. But I'm also collaborating with the Supreme Court of the Republic of Kazakhstan for 5 years already as a part of the International Council. And today I have a chance to present in another role, and that is very much appreciated. And second of all, Russia and Kazakhstan are probably the closest in terms of mentality and social cultural context and reality. I think that Kazakhstani judges might be interested in Russian experience, and it might be beneficial. And other practical thing, first half of the day in the distance learning format, we launch two help courses in Russia. First in Kazan, first course where I am tutor, freedom and actually after 30 minutes of work with Kazan, I already can tell you about that. Of course, I join. Congratulations to Diana and Mikhail, and from Tatarstan on behalf of the Supreme Court of the Republic of Tatarstan and the top management of the Kazan filial of the Russian Institute of Justice. Mikhail, congratulations to you, because your appointment is very much noticed, because you are known as a high-level professional and as a patriot of Russia, and therefore we are very enthusiastic about that in Russia. Can we see my presentation on the screen? Since colleagues already told you about the preparation of health courses, I would like to tell you about the significance of health program in Russia, and not only in Russia. Just a couple of words how the training happens in Russia. We have a lot of judges, about 33,000, and they are being trained. The federal judges are trained only in Moscow, in Russia State University. We have 10 branches in St. Petersburg and up to Vladivostok, but all federal judges are trained only in Moscow. After the decree of the president about appointment as a judge, they go to training, and they are trained initially in Moscow. And training of the federal judges also happen in Moscow once a year or once in several years. Every judge has to have a qualification training in line with the curriculum appointed by the Supreme Court. And also we have the other judge categories which should be trained in continued entities of the Russian Federation. We have a school where we have students grade from 1st to 11th. Also, we have a college for vocational training on judicial administration and other programs already. We have undergraduate degree, graduate degree, and PhD degree, doctorate training, and also for the qualification improvement for the judges who were appointed just now, and also for the already experienced judges. They are subdivided into categories for criminal proceedings, for civil proceedings. There are also special trainings for small-scale courts for judges, and they are not divided there. into smaller groups. We have also uh, for other types of courts, and we have separate training for the chair people of the regional courts. We have several words about the HELP program. HELP program is not an obligatory for the training of judges in Russian Federation. It was launched in 2015 in Russia, and it is implemented on the territory of Russian Federation through partner organizations. And the first partner is the Russian State University of Justice. Legal community of Russia is involved in the HELP program. Not so long ago, the active training of judges has started in 2018. But still, the significance of the HELP program is quite high. Why? Because this program enables us to have a new perspective on quite regular things. 15 years ago, when I just started to work in the University of Justice, retired judge, very experienced, with their high reputation, he said that judges become craftsmen in their in the profession and perform the same operations, putting up together the procedural actions and so on. It was not so clear for me, and it was quite surprising, but I completely agree with Mr. Alikakos, who said that the goal of the training institutions is to train judges for 21st century. And we clearly understand that if we want to change perception, we need to change our mentality. Here I would like to share a quote of Einstein, who said, "You will never be able to resolve a problem if you think the same who actually came up with this problem." And the help helps us, supports us in a developing a new perspective. It enables us to use European approaches and taking into consideration existing tools and existing legislation to be very accurate and very creative in resolving conflicts and problems for what judges exist to resolve social conflicts. I would like to mention that the help is very beneficial, and probably know that Russia is not always does not always have very calm and very stable relations with European associations. European values sometimes mean not as initially set, and due to some mass media misinterpretation, European values were understood somehow negatively, and this terminology this negativity is nivelated that the judges and other judicial professionals learn more about the European court, where the help courses are very helpful. It's not just that the LGBT community parades, but also something which is very common in the global perspective, something which is a part of the norms and regulations which were ratified in the Declaration of Human Rights, International Pact on International and Human Rights. It's not just a value of a specific territory or group of countries. Those are universal values, and help actually supports us in changing perception of our people, not so quickly as we want to. Einstein, if you want to see the result of your work at once, you should become a woodsman. But we cannot be all in this business, but we are still seeing how the attitude and perception of judges is changing, and we see how their approaches are changing. What kind of courses of help are implemented and are in the process for Russian legal community? This is the introduction to the European Convention on Human Rights, combating human trafficking and violence against women, child-friendly justice, motivation of court decisions, prohibition of ill treatment, right to liberty and security of person, pre-trial investigation, and the European Convention on Human Rights. We are also preparing 3 new courses: labor rights and social charter. This is ethics course for judges, lawyers, and prosecutors, and the course for the environmental rights. How geographically and numerically help is operating in Russia? We have 25 regions engaged, from St. Petersburg to Chukotka and Sakhalin, and about 1,500 judges and employees of the judicial system at all levels, starting from the Supreme Court of the Russian Federation and up to the courts of the constituent entities of the Russian Federation, and military courts are also part of it. Help courses are not only online or offline. It also include other events, roundtables, conferences, practical and scientific seminars, where we are experimenting with different interactive methods of teaching. And a very good interactive exercise is that when the judges can be role-playing, and they can be acting as prosecutors or lawyers, when we divide them into mini groups, when we work in groups, they start thinking and trying to walk the shoes of other roles. And what other experience of Russia can be relevant and advantages? We have comprehensive training and qualification, upskilling. When the group of judges come to us, we offer them in parallel to have one of the help courses. They choose the course, and while they are here at the training premises, they are also at the same time having this online course. They can discuss important things offline, not only on the platform, and this practice provides its positive results.
What are the first preliminary outcomes of implementation of this program in the Russian Federation? In the first of all, the law enforcement practice changes, and literally after 1 year of help program being introduced to Russia, we can evidence how the quality of court decisions is changing by addressing topics that we address in the courses. For example, the number of incarceration decisions are reducing, and the alternative detention methods are being used. And we can also see how the mentality changes, like how the law enforcement leads to changes in the legislation, in the decrease of the Supreme Court Judicial Council, and we can also see how judges try to comprehend European approaches and start to apply them in practical activity. And when they see something that needs to be corrected, for example, introduce some details to the law or changes law enforcement practice, then also this works in a preventive manner. So appealing to the practice of the European Human Rights Court is becoming more common for the judges of different levels. If before it was quite rare in the court decisions to see the references to the European Convention on Human Rights, now we can see more and more of those references. It's very important to see this program via the lenses of integration, because when the courts of the Russian Federation consider themselves as part of one community, from the Lisbon to the Vladivostok, they consider that they are not alone, that there are common standards that are being kept maintained by all the judges in Europe. And it's very especially important to the judges working in the remote regions. In 2021, under this program, we had a group of judges from Sakhalin Island, and the judges' assistants from the Chukotka Peninsula. They are very far away located. But thanks to that program, they felt engaged, not into the Russian community, but also they feel part of one single European community, and it's very significant for them. And the program also cannot be underestimated in terms of the legal consciousness. Judges start understanding more how to enforce those rights and freedoms embedded in the Constitution, decisions of the Constitutional Court written in the codes, but on hands they do have some tools, practical tools, how to mention them, particularly in the judicial acts and decisions. So whatever before was placed between the lines now is stated kind of out loud and explicitly in the judicial court's decisions. The trust to the international remedies of human rights have increased, and of course the help program became essential in the area of career building. Actually, it happened to be that help certificate from the Council of Europe is quite prestigious, and the colleagues from different regions, for example, judge assistants, the secretaries of court hearings, young people with quite low salaries, but when they pass the course and get the certificate of help, they receive an educational document from the Council of Europe. It's crucial for them for career building purposes, and it's also important for their portfolios and their further active leadership. So in Russia, there is a problem that the judges actually the judges do not pass the courses. Only a few people that enroll into the courses, they do not complete them, maybe because of some family circumstances, but because of some peak loads. And there are some kind of unique cases when people do not pass these certificates and courses, but these courses are voluntary. Nobody is forcing anyone. Judges and judge assistants are consciously going to that courses, and we evidence the picture when the judges have, after passing the first course, they enroll in the second, in the third courses, those that are relevant to the topic of their activity. We have the group of such judges that are successfully passing course after course. What are the trends in developing this program in the Russian Federation? First of all, is covering larger territories and covering other regions. I think the experience of other countries will be useful to Kazakhstan as well. So possibly some courses will be introduced here in Kazakhstan. Number of judges and in general, judicial system is enlarging, and the number of courses is enlarging for the judges community. And it's also quite promising implementation of these courses into the national system of for training of judges. Maybe it's voluntary now, but there will be a day when some elective courses will be introduced, like Diana mentioned, for Moldova. Possibly we will be proposing those for professional development. Also, we will be proposing help. And different scientific and practical events are very in need of help courses, because we need to collect to kind of gather different people from different legal professions. We have experience of organizing regional events. 2 weeks ago, we had an offline event in Khabarovsk in the for example, from Sakhalinsk, Blagoveshchensk, and Komsomolsk, Irkutsk, and Ulan-Ude cities. So the whole region was covered in these regional events, and we invited not only judges, but Ministry of Interior Affairs, Prosecutor Office, the investigating committee, and the human rights ombudsman was also represented. So this kind of events, thanks to the HELP program, they promote and facilitate the level of improving level of legal consciousness, and by the end of the day, ensuring the rights and freedoms execution. And it, of course, facilitates development of democracy and statesmanship. Thank you very much, Ms. Oksana. So we had a question to you while you were presenting. I would be happy to give the floor to our colleague Vasily Lukashevich, the chief referent of the Secretariat of the European Court of Human Rights. Thank you very much, Ms. Oksana. I do have a question, rather on the age of threshold of theory and practice. Since you've been dealing with HELP program for a long time, you are the tutor, but you're tightly also related to the research on how the judicial system is functioning. You have a lot of connections with the judges community. Could you please point out some main trends of how these HELP courses impact? Are there any specific outcomes that these HELP courses are being implemented in Russian Federation? Is there any feedback on, for example, choosing some detention methods like incarceration, or the 125th article of the Criminal Procedure Code with regard to appealing the actions of the investigating authorities? So any feedback on how it positively or negatively influenced the practice, and any trends in criminal procedures in Russian Federation? Yes, thank you very much, says Oksana. It's absolutely correct. Well, there are some positive trends. Maybe they are not as quick as desired. We cannot see the immediate result. It cannot happen overnight. There could be there is a sustainable trend, and there is a positive feedback from the judges. And the judges started to understand what the European Court on Human Rights wants from them, and what the Russian Federation Authority wants from them, and what's the essence what in the rulings of the court, and not everybody knows how to precisely apply them. There are a lot of examples on how the HELP program works in the regions. For example, in Bryansk region, the chairman of one of the courts is undergoing the course on a security of a person, and once a month he getting this knowledge, he goes to the investigators and tells about the position of the European Court, about what the courts are waiting in their appeals. And we can see that during 2 years, 30% of the appeals to the 30% of the appeals of the investigators, for example, have reduced, and we can see that the home incarceration is more used, for example. So the detention methods are changing by 30%. And we can see the national adaptation of your courses, like, for example, methodological recommendations that you develop, and the templates of the court decisions or rulings are very helpful, because everybody needs to kind of acknowledge that the quality of court decisions is changes, but the quality or the approaches and the mindset of judges is changing in the areas that for the court decisions to be clear, understandable, predictable, and ensuring basic human rights. Thank you very much for your question and your answer. I think both question and answer had an idea that HELP is a very effective tool in order to modify or change the court's practice and harmonization of the national judicial practice with the requirements of the international conventions of the Council of Europe, including the European Convention on Human Rights and the precedent and case practice of the European Union. We do have very specific examples. Thank you very much for appealing to them. Okay. There is a logical ending of our list of presentations. We have Rector of the Academy of Justice under the Supreme Court of the Republic of Kazakhstan, Ms. Zauresh Baymoldina. It's devoted to modernizing the training system and professional development system of judges in the Republic of Kazakhstan. Thank you very much. I distinguished audience and participants of the round table. I would like to join the congratulations already expressed by my colleagues, the previous presenters addressed to Mikhail and Diana. And I assume that those positions are the landmark positions. It means that you are, as persons, are highly trusted and your activity is trusted. I would like to wish you further fruitful and successful cooperation in your future activity. Coming back to the topic of my presentation, of course, the decisive kind of point for the lawfulness of the decisions taken by the court is the availability of the trustful training and professional development system. That's why modernizing this program is one of the areas of the judicial reform in Kazakhstan. Efficiency of the this system depends on the quality of training for the judges, where the important role is played by the methods, forms, and the content of the training for future and active judges. So we are based on the fact that education shall be fundamental, specialized, and continuous. In order to ensure these three factors, the presidential decree of the Republic of Kazakhstan as of February 18th, 2016, there was the Academy of Justice, established as the supreme training body having special status. The Supreme Court of the Republic of Kazakhstan is the authorized agency managing the Academy. The main areas for the Academy's activity is, first of all, implementation of the training postgraduate degree programs. Secondly, is retraining and professional development of judges and the judicial system staff. And third one, research activity. Since the Academy, being the independent specialized educational institution, was established quite recently, naturally the active work is being done on increasing its role in training the staff for the judicial system. This work is being done in a continuous way. At the end of 2019, there was a new model of the Academy was approved by the Supreme Court. And according to this new model, during 2020, there was a work completed on establishment and improving all the regulatory framework for the Academy's operations, given its transition to a new model. In February this year, there was a concept approved for the development of the Academy up to 2023 that highlighted the main objectives for the forthcoming period. The concept was approved by the instruction of the Chief Justice, because the Supreme Court, as I said, is the authorized agency regulating our Academy. According to this concept, the main goal of the Academy is the staged or phased competitiveness of the Academy on the market of educational services as a specialized tertiary institution providing training, retraining, and professional development among court judges. With regard to the specific activities of the Academy, first of all, in the area of training the staff on master degree courses. For example, we are talking about different postgraduate education, and we even didn't reach the stage of opening the doctorate degrees. First of all, the master degree admission is done based on the state order. Every year there are 60 people enrolled, so everyone is being educated using the Republican budget funds. The civil servants that are entering master degree courses are being applied the following requirements. First of all, they shall be of the age of 29 years old, at least, because according to the constitutional law on the status of judges, the judge shall be a person that has reached the age of 30 years old. Secondly, higher legal education. And third, at the moment of enrollment, have an experience of 4 years at least in legal profession. Of course, postgraduate studies, since establishment of the Academy, the master's degree programs have been upgraded. First of all, in 2020, there were new rules approved for the admission to the Academy. They were improved and streamlined the mechanisms for selecting candidates to receive the right to get training for them in order to be future to become the judges. Of course, these rules were modified in order to eliminate subjective factors. First of all, we have increased the term of 4 months. It used to be 21 days. Of course, it will create a higher competitive environment. Secondly, the interview was eliminated. It was replaced by computer tests based on competences. And of course, it will eliminate any human impact at the stage of master degree admission. Cases, and different case studies, and as there was kind of assessed jointly, now are being assessed as separate stages. So first, there should be some case studies resolved, and secondly, essay, and each of those stages is independently assessed. And the examination commission members have been enlarged. Apart from the Supreme Court judges, tutors of the Academy, it also includes the judges from the local courts. The template curriculum was approved. It's flexible, but it allows to supporting the educational program in a relevant manner. So a 2-year courses have been replaced by 1-year master degree courses, because we believe now in better profile education, and the percentage of the practical education has been increased. Now it's 3/4 of the total volume of education on the master degree course. Second, then the approach to the kind of subjects of the master degree papers was changed. Now all the proposals being received from the first instance courts, the Supreme Courts, so are collected. We are based on the needs, therefore, on the of the judicial system, ensuring its applied measure. As a result of preparing this master degree papers, so there will be expected some improvement in the practical activities, and in some cases there are some proposals on even upgrading, improving the current legislation. What is planned for the forthcoming period? There was a concept approved. Next slide.
As I mentioned previously, we have only representatives of the government authorities, but we would like to widen categories of our master students by providing this access to the legal professionals not from government sector. We believe that in this regard we will expand competition, and we will be able to choose the best candidates in terms of preparation and qualification. We already had the scientific and the legal expertise stages finalized, and currently we are at the stage of clearing that with government authorities. We are providing the this services on master degrees on a paid basis. So it means that we will enroll all the willing candidates, and further they will be eligible to become judges. And even though their training was not funded from the government budget but was actually self-funded. Currently, the Minister of Justice already registered these amendments into the provision of paid services regulation, and starting next year, Academy will be providing the services on a paid basis. We are also working on creating the pool of potential lecturers as a part-time employers, as a part-time employees to combine practical and empirical training. We involve existing judges from Supreme Court, from other courts, retired court judges, also employees of the departments and experts of different organizations, including international organizations. And of course, we are planning next year to finalize our activities on the PhD degrees and disciplinary council. I believe it will be very beneficial for a judicial system, but also for all the people willing to improve their qualification. As for the second block about the training and upskilling for judges. As a rule in Academy, we have annual training and retraining for 600 judges and the workers of the judicial system. Currently in Kazakhstan, we have 2,500 judges. Every judge has a possibility once in 3 years, in line with the constitutional law on judicial and court system, to be trained and upskilled. What we have here, we change approach to the schedule. Previously, we were looking at the requirements and needs of the regions in numerous aspects, but now we have also other aspects like judges who were not trained in the new regulations. It's not only about existing judges, but new appointees. It is also about the newly established administrative courts. And also we have a sphere of this legislation and practice has been expanded significantly. Therefore, elections will be organized up to not only on the central government level, but also on the local level as well. In 2021, since the focus was on practical preparation, we increased the number of employees working with our judges in terms of the number of lecturers from Supreme and local courts, and also experts from international organizations. Big help in this regard was provided by two German associations, German Community on International Cooperation, GIZ, and also ERZA. And also big help is provided by the Friedrich Ebert Foundation. In addition to that, we closely collaborate with the American Association of Legal Expert Barani and with the Council of Europe, OCTE, UN. Also, that was discussed quite in detail in AAFC. We have good collaboration with the Astana International Financial Center now and with the court of AAFC to actually work with academicians, arbitration and court of AAFC to have them as lecturers for our judges who come to our institution for training. With that, we believe that during the training, in the course of training, we put a big emphasis on the doctrinal provisions which were reflected in our existing legislation in order to improve the application practices I think it will be very great help for the judges in applying regulations. Tomorrow we will have a scheduled meeting with the representatives of HELP program, and we believe that this work will be streamlined with the courses offered by this program. We believe that the additional training and education should become one of the most demanded areas of the Academy on the market of educational services. In this case, we should be applying innovative approaches to the organization of the training programs and implementation of additional training, also on a paid basis. What's being planned by the Academy to improve the forms of additional education and auxiliary programs, modernization of the programs for training and retraining. Now we are trying to move away from the general courses to tailored, individualized curriculum in the context of the professional needs of the judges. For the second half of the year, the courses were already grouped by topicality. From 2022, we are planning to shift to the implementation of courses on specific issues. Here, we are conducting a big work with local courts to identify what their needs are in the specific topics and issues in the judicial system and legal sector. We are currently working on expanding spectrum of educational programs on a charged basis. In particular, starting from the current year, we are planning to have charged courses for this following programs: training and qualification courses online for other representatives of legal sector, lawyers, mediators, notaries, and so on. We believe that Academy will be able to provide quality services to these professionals who are also working in the legal activities, and we hope that it will resolve many issues which are linked to the implementation and execution of legal verdicts, and also to dispute resolution. And further, we are planning to have courses to prepare for qualification exams to become judges, both online and offline. We are also planning to have courses for the future students to become master students of our Academy. Also, it is about individualization and tailoring of the education system for judges and workers of the judicial system. To improve the auxiliary programs and additional education programs, we are planning to shift from general courses to individualized tailored program. Now, of course, it will require not only changes in the format of the training courses in terms of the duration, schedule, topics, and so on, but as you perfectly understand, this is about electing by the judges of the corresponding courses depending on preferences starting next year. And in order to implement individualization in judges training, we need to organize a set of activities, and we are currently working with the local courts on that. We are trying to identify what the needs are for the specific topics among judges, and to develop the schedule of trainings and qualification courses. It is also important to have individualized training and to select trainers, tutors, lecturers, and so on. Therefore, Academy has a lot to achieve, to think, to convert, to improve preparation of the future human resources for judicial system, but also for all the other professionals which are included into the court-related activities. Thank you very much for your attention. Thank you very much, Zauresh Hamitovna, for your presentation, for sharing your achievements and your processes with us, particularly for sharing your future plans. And in particular, since what you've mentioned at the end, identification of needs of the judges in terms of their individual training. This work is very close to what my colleagues do within the help program, because identification of needs and demands determine successful results. And with big interest, we will continue our discussions, including tomorrow's meeting. Thank you very much for your interest in cooperation with the Council of Europe. Thank you very much for your warm words and wishes. In my turn, I would also like to wish you to successfully implement all your ambitious plans you mentioned during your presentation, and please be assured that I and my colleagues are here to help you. Kristina Khokhlova, she's present here in this hall, and as Eva mentioned, she's coordinator of the program in Kazakhstan and in other countries of Central Asia, and therefore she is ready to answer any questions. That is the end of our session, and we are moving to our closing part. Just to highlight the role of such important educational program as HELP, its role as a tool of strengthening international legal community on the territory of Europe and bigger Europe, which also covers bigger part of Eurasia. In our recent, we had our recent event in Khabarovsk in Far East, and quite often that happens when we go to very distant regions in Kazakhstan and also in other countries of the region. We can organize such events not only in the capital cities but also in the regions. Everything depends on how much needs will be identified and defined. It will be depending on the topics in demand by the judicial community. If we properly set methodology and topics, I believe we will be successful. And strengthening of the judicial power cannot be imagined without the legal education programs and organizations in line with the new standards of 21st century, including elements of international law, European law. And you've seen that our program allows actually to perform that. It has huge expert potential. All the speakers at this session are examples of practical implementation of the goals announced within the program, and quite successful implementation with the specific outcomes and outputs already, as we were able to see in the development of the judicial practice and judicial system development. We are moving towards the final part. We have two presentations here within the concluding part of the roundtable, and with your permission, I would like to pass the floor to Mr. Vladimir Wenger, who is expert of Venice Commission, ex-head of the Secretariat of the Committee of the Rada on the Legal Policy and Justice, Executive Director of the Center of Research and Legal Regulation. Thank you very much. Good afternoon, colleagues. I have very interesting mission to draw conclusions and to identify perspective areas for the next steps. and of some interesting formats for cooperation. To actually serve the purpose of our bilingual forum, I would like to switch to English language, and I will be back to Russian shortly.
At this roundtable, we had a really wide range of issues related to development of the judiciary. It's a really great opportunity for us not only to have excellent presentations, but also have very interesting discussions, even sometimes non-comfortable questions for the panelists, but nevertheless, the wide range of questions covered 4 main and interesting blocks. We started yesterday with criminal procedure legislation and perspectives for further development in Kazakhstan. And after that, we had a small discussion on administrative justice and its implementation in Kazakhstan and in other countries. Then we had really wonderful presentation of the Kazakhstan experience on IT solutions in judiciary and in other relevant fields in communication between courts, judges, prosecutors, attorneys, and other participants of the court proceedings. And just today we were discussing about the tools for trainings and international cooperation. To sum up some conclusions on that 4 blocks, just yesterday we started with a criminal procedure with introductory speech of the president, honorable president of the Supreme Court of the Kazakhstan, Zakir Rukhmanovich Asmanov. And this introductory speech made a fairly thorough report on needs of the Kazakhstan on development of the criminal procedure, some special and implementing and introducing some new tools for adversarial proceedings in criminal process. This speech was leitmotif of the whole block. And the main thesis of that discussion, we can figure out that in Kazakhstan, sadly to say, like in other post-Soviet countries, we still have some kind of accusatory nature of the trial when the judges think and in some cases have a special perception of their role in criminal procedures, like maybe representatives or even like mentors for the prosecutors. And their activities and their procedures still be accusatory for defendant side of the criminal procedure. To go against this approach, there is an idea to implement more deeply in Kazakhstan criminal procedure legislation American-style procedures, which are quite good presented in Estonia and some other countries. And we had a really great presentation from Pavel Petrovich Goncharov and also by the judge of the Supreme Court of the Kazakhstan, Gulnara Mergenova. They presented for us not only experience of the Estonia, but also key points to connect this idea with Kazakhstan approach and reality. And another thesis for that block was that it's needed not only discussion on trial procedures and special criminal procedure amendments, but also pre-trial, new pre-trial tools which could provide more equal treatment for both sides of the criminal procedure. And in that way, it's really important to provide attorneys with new and more deep tools on gathering evidence or doing any other activities to protect people and to guarantee human rights in criminal procedure. The second block was quite useful and interesting, and we have such a wave in all post-Soviet countries on administrative justice and introducing of the administrative courts, and even in European countries, this experience is quite useful because it means protection of the human, of the citizen, against state authorities, public authorities, and state as a whole. And the leitmotif speech of that session was made by the judge of the Supreme Court, and it was really useful to listen achievements from people who are deeply involved in implementing administrative justice. Just for the last 4 months, since July 2021, you already have quite great results. And the most impressive conclusion of that block is that more than half of the complaints against the state, against the regulatory acts and some other administrative acts are successful for the plaintiffs, and that suits are really useful. The main idea of the administrative justice is to provide citizens with new tools, not only to protect their rights, but also to create a new style of understanding and perception of administrative procedure and of good governance principles. From this point of view, the speech of Mr. Roman Anatolyevich Podoprigora was really wonderful to figure out some weak points at that field, some weak points of the perception by the lawyers of good governance principles and administrative justice too. Very interesting third block on IT solutions and international cooperation in judiciary were really wonderful. I'm really impressed with the results of the Kazakhstan and some other countries. And it means not only communication between the sides in court proceedings and some kind of simplification of the activities, court activities, but also it is about perception by the people, by the citizens of the courts, and just developing their authority and their positive influence on a civil society development. From this point of view, it is really useful for us to remember that all that activities should be made in strict accordance with international principles, and from this point of view, the report from the Slovenia was quite interesting and figured out the main idea that even new IT solutions which are stimulated by the COVID pandemic should be taken in some kind of strategic planning, in strong perception of the principle of the rule of law and its components. First of all, transparency, accountability, non-discrimination, etc., etc. And finally, today we were talking about trainings, not only for judges, not only for the some administration staff in courts, but also for legal specialists, for legal practitioners. From this point of view, health program is quite useful, not only to provide a new way for getting new knowledge and maybe some new skills, but it's also a really great tool to unite different countries with different cultures, with different legislation to provide common understanding of the human rights values, main tools for protection of human rights, and of course, really good tool for sharing their experience. And I hope it will be really useful, especially for Kazakhstan and representatives of the Supreme Court of the Kazakhstan and for the development. И подводя
And wrapping up, let's say, in general, for today's event, I would like to mention that uniting these 4 blocks indeed narrowed down our opportunities in terms of time resources. We didn't have possibly enough time to discuss, to debate enough, and to have deeper deliverables. However, from my point of view, this successful merger of 4 blocks and criminal proceedings and administrative procedure and proceeding in the Kazakhstani experience, it was even more interesting, as well as the professional development tools and advanced technologies gives an opportunity to more comprehensively approach international standards and share the experience of different countries represented here. And not only, I really hope that those areas and directions of development that were introduced during this event will be having new steps and new forms of cooperation, and of course will bring good outcomes not only for Kazakhstan but also for our joint work. Thank you. Thank you very much, Mr. Wenger. It was an easy task, actually, to kind of wrap up and summarize the discussions happening during 2 days. You did it perfectly, and if I understand correctly, there will be some written summary that will be distributed to all of the participants with the attachment of all those materials presented during this conference, including the PPTs of the last session as well as the previous sessions. I'm sure that these materials will be quite demanded by all of the participants and beyond the audience of the conference, because these materials, as I believe, lay a very serious foundation for future work and will be waiting for dissemination of those materials. Very much. Distinguished colleagues, any event shall end with the presentation of the host. And before I give the floor to the Supreme Court of the Republic of Kazakhstan, a judge of the Supreme Court of the Republic of Kazakhstan, on behalf of the Council of Europe, I would like to thank all of the participants and organizers of this event. And we managed to reach 2 significant successes. From organizational point of view, we already noted that since yesterday this event was organized in the record minimum of time, and it became one of the largest and possibly the largest event since the beginning of pandemic in terms of the number of international guests managed to arrive to the capital of the Republic of Kazakhstan and personally participate in the discussions. I would like to thank all the organizers and our Kazakhstani colleagues who demonstrated very strong efficiency in preparation and receiving all delegations. And special thanks go to my colleagues of Venice Commission, Mr. Sergei Anatolievich and his colleagues, because you were the coordinator in preparing for this event. And it was quite logical because you have a long-standing cooperation with Kazakhstan for more than 25 years. And of course, when we've been mentioning internal coordination inside the Council of Europe, you were the best placed. And I also wanted to thank all of other colleagues from the Council of Europe who enriched this event, and among those, the European Commission on the Justice Efficiency and the chairman, Mr. Ramin Gurbanov, who had a presentation yesterday, and all of the experts from CPECH that were very fast in responding to our invitation. And regardless of not being able to come to Nur-Sultan in person, actively participated in our discussions and who provided very constructive presentations that will be attached to the conference materials. I would like to thank also all the experts who participated in our concluding session on HELP program, and also wanted to highlight higher level of readiness on coming to face-to-face discussions and participate in the conference. And a part of the organization, we shall also point on the substantial part of it. As Vladimir mentioned, it was a quite rich material, which is at our disposal now. And the discussion that happened opens many new tracks and doors for future work. Of course, the criminal process, the importance of which was highlighted yesterday by the Chief Justice of the Republic of Kazakhstan, as well as in other sessions, we can also evidence new tracks within the frames of the bilateral meetings happened within the framework of this conference. There is a demand in discussing these topics so we can plan for this work within the frames of cooperation with the Republic of Kazakhstan as well as other Central Asian republics that were closely watching our conference in the online mode. Special thanks goes to the technical staff who did almost impossible things, and the quality of communications, I would say it was flawless. We wouldn't have any technical glitch. We had a perfect screen, and those participants who participated online, we felt as if they were participating right here. Thank you very much to the interpreters, without whom it would not be possible to organize such a fateful international event. And at this, I would like to finalize my closing remarks. I would happily give the floor for the closing remarks to our good peer, friend, who was actively cooperating with us on the Council of Europe platform, Mr. Balkin, the Supreme Court judge. Thank you very much, says Mr. Balkin Matyar. It's a great pleasure for me to have an opportunity to meet once again our good old peers and friends in the offline mode, in the online mode, and also have a chance to meet with the experts that I meet for the first time. Couple of words to the colleagues who are in Strasbourg and other geographical locations.
I'd like to express my gratitude for such enormous efforts in promoting humanitarian values from Council of Europe, from European Union. I think that it's very important in this time to develop human rights, to support rule of law, democracy standards, and to provide like some kind of a reply to security issues, security challenges in Eurasia. Уважаемые коллеги, я хочу лично...
Distinguished colleagues, I would like to personally reconfirm multi-year kind of achievements of the Council of Europe, European Union in supporting and promoting humanitarian values, human rights, rule of law on the Eurasian space. As of now, Council of Europe, for example, taking the Council of Europe as one of the oldest international institutions with a history of more than 70 years, and the geography of this organization covering 47 countries, 800 million people. So the Council of Europe and the EU law becomes the heritage of the modern civilization. We've been considering in the historical aspect with the Rome law system, but the Council of Europe, during its experience based on the different European conventions, have gathered significant experience. And this experience is important for our region because, in particular, by, for example, ruling the cases and have trials, I was facing problems. Even as a judge, you suffer and you try to find the original causes of violating the basic human rights. And here, I think the problems or challenges, I think, are similar to some extent with regard to the post-Soviet countries, although the path of independence was quite significant and there are a lot of achievements, and Russian Federations for 25 years have been the member of the Council of Europe as well as the other post-Soviet countries. So the problem from my point of view, one of the reasons for this problem is the historical aspect of the tradition of the state dominating over a human being. Once reading the library of the Supreme Court, I came across one publication. It was the article of prior to revolution legal specialist Mr. Lublinsky, and in his research article about the human rights was touching upon the issue that in the historical aspect, the rights and freedom and the tendency of state dominating over a human being has its roots. And therefore the project and the program on the rule of law in the Central Asia is unique in terms of its nature. And we are very happy, and on behalf of our Kazakhstani colleagues, we are very happy to join this program and to support this. HELP program is a unique one, and I'm using this program. Personally, I participated in a great event that happened in April, which was TOT event, and the success also actually, the professional development courses happened in the Moscow State International Relations University were also quite informative. My colleagues are looking at the presentations of the speakers organized also by the Council of Europe at this event. Today's and yesterday's sessions were carefully selected. I think they fully correspond to the demands, to the trends that currently are observed in our republic in terms of the development of the criminal and administrative justice. Indeed, the efficiency of justice, including cooperation with CEPEJ, opens us huge doors to check ourselves, to identify future directions for improving the judicial system. And of course, the session on legal education on health platform was a unique tool. I was curious to learn about the ethics of judges and ethics of the advocates, and also it was a unique course on business support, and Eva already mentioned those courses. So I think that The materials of our today's event will be very much demanded to ensure this future development of these promising areas. And once again, on behalf of the host, on behalf of the Republic of Kazakhstan, I would like to mention that our community of judges is fully ready to become a regional hub, both for Central Asia republics, for our neighboring countries, in terms of developing projects and programs that are kindly and provided with courtesy by our colleagues. Thank you very much.
Все, спасибо. Наша конференция завершена.
Thank you very much. Our conference is over. Have a safe flight if you are flying back, and see you next time.